हेलो एवरीवन। इस वीडियो में हम डिस्कस करेंगे कंप्लेंट और एफआईआर का डिफरेंस, विच इज़ वेरी इंपॉर्टेंट इन क्रिमिनल प्रोसीजर कोड. Complaint is defined under section 2 subclause D of CRPC and FIR is given under section 154 of CRPC. So this is the first difference. And next is, complaint is an allegation which is made orally or in writing to a magistrate. So complaint is always made to a magistrate, while FIR is given to an officer in charge of a police station, not to magistrate. Third difference is, a complaint may relate to a cognizable or non-cognizable offence, while FIR is always related to a cognizable offence. And cognizable offence is also defined under section 2 subclause C of CRPC. Next difference is, a magistrate take cognizance of an offence on a complaint made to him, but he cannot do so in FIR. Magistrate can take direct cognizance on complaint, but he cannot do so in FIR cases, because in FIR cases he take cognizance only on police report. In FIR, magistrate take cognizance on report of police officer under section 190 subclause 1 subclause B. Next difference is, complaint does not include the report of a police officer, and this is provided under section 2 subclause D explanation of CRPC, while FIR of an offence may be given by anybody including police officer. So complaint is never given by police officer, and FIR, it may be given by anybody including police officer. Next difference, we will discuss the difference of inquiry and trial. Inquiry does not include necessarily, an inquiry does not necessarily means inquiry into an offence. It may relate to a matter which are not offences. So inquiry may be relating to offence or maybe some other matters which are not offence, while trial on the other hand is always of an offence. So trial always held of an offence. Next difference is, an inquiry in respect of offence never end in conviction or acquittal. At the most, it may result in discharge or commitment of case to the session. So after inquiry, the result is never conviction or acquittal of the accused. Rather, it may result in discharge of the accused when there is no material in the case, or it may result in committal to the court of session when the cases are triable by court of session. While in case of trial, a trial must invariably end in acquittal or conviction of the accused. So the result of the trial, at the conclusion of the trial, the accused is either convicted or he is either acquitted. Next difference is, inquiry precedes trial. So inquiry is before the trial, while a trial follows an inquiry, and after the inquiry the trial is started. Next difference is, an inquiry is the second stage in a criminal case, and a trial is the third stage in a criminal case. So what is the first stage? First stage is investigation, second stage is inquiry, and then third stage is trial. Next difference is, the inquiry include every inquiry other than a trial conducted under the Code of Criminal Procedure by a magistrate or a court. So it is kind of a residuary. And other than the trial, everything which is conducted by the magistrate or the court, other than the trial, it will be inquiry. While a trial is the examination and determination of a cause by a judicial tribunal or a court which has jurisdiction over it. Our next difference is a difference between investigation and inquiry. An investigation is made by a police officer or by some person authorized by a magistrate. Investigation is defined under section 2 subclause H of CRPC, while inquiry is defined under section 2 subclause G of CRPC, and inquiry is always made by a magistrate or a court. It is never made by a police officer. Next difference is, The object of investigation is to collect evidence for the prosecution of the case, and the object of the inquiry is to determine the truth or false of a certain fact with a view to take further action. Next difference is investigation is the first stage of a criminal case, while inquiry is the second stage of a criminal case. Next difference is investigation is not a judicial proceeding and it is not considered to be a part of judicial proceeding, while inquiry is a part of judicial proceeding because it is also conducted by magistrate or court.